While it might look good on paper, the ICC is structurally ineffective. The report in 2023 explains the ICC's transparency has been perfected. Trials take place behind closed doors, and investigations take years, increasing the perception that the court is biased and politicized. It is determined it will be vetted with the bad hands far more than I against today's resolution. Our first argument concerns a counterproductive court. The International Criminal Court has struggled with inefficiency and ineffectiveness since its inception. Wilmshurst in 2016 finds that the court's proceedings are excessively long and cumbersome. Despite spending a staggering $1.5 billion, the ICC has only successfully convicted 3 individuals for international crimes. This demonstrates not only inefficiency, but also fundamental failure in delivering justice. Moreover, the ICC's involvement in conflicts does more harm than good. Dursma, the Center for Security Studies in 2020 finds that when the ICC intervenes, peace is concluded in only 4% of conflicts compared to 25% when the court stays out of the process. That means that ICC interference reduces the likelihood of peace by nearly 85%. Even worse, the ICC doesn't just fail, it actively undermines organizations that are better suited to resolving conflicts. As Bosco in 2013 confirms, regional organizations are 7 times more likely to negotiate an agreement that successfully ends hostilities. This is because they have deeper contextual knowledge, stronger diplomatic ties, and greater flexibility in crafting solutions tailored to specific conflicts. Yet, the ICC's intervention sidelines these more effective actors, worsening global instability. And rather than subduing conflict, the ICC prolongs and exacerbates it. Perot in 2017 finds that ICC involvement creates perverse incentives for leaders to resist prosecution at all costs, leading to conflicts lasting 47% longer than they otherwise would. Instead of holding war criminals accountable, the ICC gives them a reason to cling to power and prolong bloodshed. If the U.S. were to join the ICC, it would be forced to bankroll this failing institution, and this is devastating, as Bellamy in 2018 finds that since 2011, global violence has surged by an astonishing 600 times. In this context, the actions of international institutions like the ICC are not just bureaucratic matters, they are a matter of life and death. Our second argument is humanitarian efforts. The U.S. military is key. Walters in 2024 finds that since World War II, the U.S. military has been the most important provider of humanitarian assistance. Aid organizations rely on the military to deliver aid, repair infrastructure, and secure criminal organizations. Unfortunately, a firm would discourage military deployments for humanitarian purposes. Hawley, a senior policy advisor at the Stimson Center, found that the United States holds a unique responsibility due to its size and sophistication that they will be heavily scrutinized by the ICC. The fear of being judged by the court will deter the U.S. from deploying forces on a large humanitarian crisis. And this is empirically proven, as Goldsmith, a Harvard law professor, finds that the U.S. threatened to pull out of peacekeeping missions unless they receive immunity before the ICC. Moreover, it will be harder to even propose humanitarian aid missions in the first place. Goldsmith continues that it will be hard to generate domestic support when there is a threat of liability, especially after Trump cut U.S. aid, one of the largest humanitarian aid programs the U.S. has passed out in the last few decades. In addition, the effectiveness of these missions will decline, as Hawley continues that U.S. military actions involve thousands of discussions, decisions, and classified documents. With ICC scrutiny, the U.S. will have to decrease troop power, investigations, and firepower. Moreover, the lengthy oversight process would hamper disaster response times. Hawley finalizes evaluation time by the ICC could delay humanitarian response time because there's massive ambiguity surrounding what constitutes a vital or non-vital mission. Indeed, Liu corroborates that the ICC takes many years, causing a discrepancy between justice and peace building. And it isn't just about the possibility for evaluation, as Hawley finds that the perception of the court is enough to cause military leaders to second-guess their actions and destroy the confidence of those in the court. Altogether, a city to Rome statute would significantly hurt humanitarian efforts. That's devastating, as humanitarian missions are crucial. US 824 concludes that in just 1 year alone, the US helped 82 million women and children access essential health services. Thus,
Can you send me
We affirm, contention 1 is cooperation. The U.S. is pulling out of international agreements now. 6 in February 10 finds that Trump is using of wrecking ball alliances and institutions. He has threatened tariffs against the EU and Canada, ordered the U.S. to pull out of the WHO and withdraw from tariffs. Thus, China's ahead. Sun, February 6. Broad effort to shore up China's economy and relations have been underway. Beijing pledged more government spending, budgetary expansion, lower interest rates. Beijing will dismantle U.S. global hegemony. Allies are key to reverse this. Jose, February 7. The U.S. still holds a key advantage in alliances. However, if it treats them worse, the allies push towards a hedging strategy, deepening ties with Beijing. Affirming increases allied co-op. Ukubo 20 finds the hardline stance taken by Trump and the U.S. ICC tussle. The U.S. should not expect support of its allies. The current global system where multilateral cooperation is disintegrating, the ICC remains an important standard bearer for international law with allies. ICC member states are specifically key to hegemony. Shepherd 21 finds the Rome Statute body is number 123 countries and most of America's allies. The U.S. has alliances to the rule of law. The ICC is a good place to start. Otherwise, the climate causes transition wars and lash out. Ken 19 finds, as China's influence increases, U.S. fear about China's power also grows. Washington makes every effort to assert its global dominance. Conflicts between the two is likely. Contention 2 is Africa. Despite limited success, the ICC is attempting to mediate in Africa. Burns 22 finds, prosecutors open cases in DRC, Uganda, Sudan, Kenya, Libya. The court has faced severe criticism for holding an African bias. Over 40 individuals indicted from African countries. However, this backfires. Jerusalem 20 finds that government perceived peace agreement as risky because this might pave the way for a arrest warrant. Sudanese al-Bashir, Libyan Ghaffari had a similar effect. Continued fighting is perceived as the only way to circumvent prosecution by the ICC. Peace concluded in 4%, 24% without ICC. Uniquely, 2025 in the Sahel region is key. Vasadu 25 finds that structural challenges lead to escalation in many countries. In 2025, the Sahel, the Lake Chad Basin, and the Horn of Africa, jihadist activity at particular risk, difficult to resolve once the genie is out of the bottle. Addressing conditions will require African efforts. Western governments should refrain from paternalism. GG24 gives two additional warrants. 2025 poly-crisis in the Sahel, coup regimes, enlist support from Wagner, and the climate impacts desertification spillover, create opportunities for actors who profit from destabilization. The ICC is structurally toothless, Vega 20. Severe crimes were left uninvestigated. Warrants for arrest cited insufficient evidence for genocide. The Rome Statute is a non-binding treaty. Outstanding arrest warrants were issued in the 2000s, a window into broken legal and architecture of the court. Even if it isn't, the U.S. will amend the Rome Statute post-act. Code 24 finds, by signing the Rome Statute, the U.S. can reshape the ICC's legal infrastructure in the direction of U.S. interests. Efficacy depends on legal resources. Members are willing to contribute. Thus, all the negative impacts about the ICC constricting U.S. activity are false. One, prefer on probability, as the U.S. is the most powerful country in the ICC, causing other members to acquiesce. Two, it's a prior question to their arguments, because the U.S. isn't forced to comply with decisions that go against the national security doctrine if you affirm. For example, Senwar No-Date finds, if the U.S. joined the ICC, it can help select ICC judges and prosecutors, helping practical American interests. That's key. Trump's foreign policy prioritizes non-intervention militarily in Africa. Donnelly 24 finds Trump's America First, a more realist approach. There will be no crusade to promote democracy and liberal principles, dramatically reduce American involvement. Alternatives are better. Alex 24. Unlike the ICC, horizontal cooperation between states allows states to do it themselves rather than rely on prosecutors by the ICC, which is reluctant to prosecute crimes committed by Western powers. Otherwise, African war goes nuclear. Deutsch no date. Nuclear war is most likely to start in Africa. Very few countries are beholden to any power. Outside powers can find alliance states. Cut the card there. Specifically, Barris 21. Great power war offers nuclear interactions. Complexities for the royal and inadvertent nuclear exchange. Any such outcome could rise to the move side one of war. Thus, we affirm.
Hey, one first question. Yeah. Just talk about your argument on how the U.S. could sort of legitimize and coordinate visas for its own users. What material way, or what material system can the U.S. utilize to actually pull the U.S. towards its own interests?
Yeah, so our evidence specifically isolates that does things like cap the courts, put U.S. justices or people who acquiesce to U.S. demands. Moreover, just the U.S. being in the organization as the most powerful country already means that other countries are likely to acquiesce.
Doesn't every country members of the ICC have one vote and one vote only?
Yeah, that's a simple way to look at it, right? Our argument is that A, that doesn't respond to the fact that the U.S. just changes the people on the panels of these ICC prosecutors and judges. But to tell you that because it's the greatest power in the world, it can force countries to acquiesce, to force their votes to go to certain things. I'll take a question. Let's talk about this argument about humanitarian efforts. So your argument claims that when we affirm the U.S. will stop doing humanitarian efforts, correct?
Right.
So there's 125 countries in the ICC. Can you give me a single example of any other nation acceding to the ICC and then stopping humanitarian efforts?
Yeah, Britain, France, UK.
Britain, France, and UK also do humanitarian efforts.
100% agree. Our argument is that the U.S. is unique in itself. Even if you win that other countries didn't necessarily stop doing humanitarian aid, the U.S. is a global superpower and it has a lot of eyes on them. And our evidence finds that in 2003, the U.S. was one of the only countries to actually pull its humanitarian aid efforts. And you'll come up here and say, oh, there's a bunch of other countries, but our evidence finds that the U.S. is the biggest contributor to human aid in itself, over 82 million.
So to clarify, you can't give me a single example that ever happened, right?
Chris,
Has Britain stopped all peacekeeping?
I'll take the question. You asked like football. On your argument on Africa, so the U.S. joins the ICC.
Yeah.
If we don't stay, what's going to happen?
Yeah, so our uniqueness is that in the Sahel region in 2025, there's increase in conflict right now. Things like increased jihadist activity and climate impacts of desertification, increased chance of conflict. If you don't do anything about it, ICC mediation backfires in this region, which prolongs this conflict, like you talked about, so which causes, which draws in nuclear powers, great powers such as the U.S. and China. That is our scenario.
What does the U.S. accede to the Rome Statute do?
Yeah, I'm really glad you asked that, right? So your case is about how the ICC does more harm than good and ineffective. We are agreeing to that, right? We say that yes, the ICC is bad when you affirm the U.S. politicizes the court to U.S. interests, and because Trump currently is focused on America first and doesn't want to do intervention to military intervention in Africa, when you affirm you stop the ICC in Africa, which solves the conflict.
Wait.
I'll take the question.
Wait, hold on. Let me clear up.
Yeah.
So the U.S. stops intervening militarily in Africa because they join the ICC.
Yes, that's right. That's right. Okay. Let's talk about ICC. What is the ICC the court of?
International.
It's the court of last resort. Sounds good.
Everybody gets a dog. Awesome. Start Online opponents' first argument about cooperation on their uniqueness evidence from Nixon and 210. It's not really good. They concede that the United States is still an individual organization with its allies such as NATO. Alliances still exist. We don't need to join the ICC. These alliances are still backing our credibility on the international stage. Second, Psalm 25 just says that Beijing will dismantle the U.S. head. Their tag is severely misconstrued. It doesn't say China is ahead, and it just says that Beijing assumes Washington's own policies will dismantle the foundations of U.S. global hegemony. It doesn't even say Beijing is getting ahead, so they're not willing to be status quo is bad. Third, their Jose evidence is really bad. Which allies are deepening ties with China? It's super inspecific. You should be skeptical of their argument. Fourth, their Okobo evidence from 2020 is also bad. It just asserts that U.S. allies in the ICC will no longer cooperate with the United States, but that's empirically untrue because the U.S. is still striking deals with allies in the ICC, disproving their argument on U.S. alliances going down in the affirmative or in the negative world. But fifth, we'd contend that the ICC would terribly decrease U.S. credibility, not what they're saying. Rose and Schaefer in 09 contend. The ICC would affect U.S. sovereignty. Rome Statute created a severely flawed institution that lacks safeguards against political manipulation and violates national sovereignty by claiming jurisdiction over non-party states. Concerns led Clinton to urge Bush not to submit the treaty to the Senate. So overall, if the U.S. joins the ICC, that's on net going to decrease our alliances, decrease our credibility on the global stage. That's not something you want and turns their case. Six, turn it again. Past U.S. actions contradict joining the court, so overall, if we join the court, it would be super hypocritical on the global stage and send our allies the message that we don't keep our word. Ali 22 finds that it's hypocritical for the United States to embrace a court it is so aggressively rejected in the past. There is no getting around the charge of hypocrisy. Supporting the ICC now is more important than formally joining. On to Africa. First, Darba Seydawa and 25 evidence doesn't mention the ICC once. It doesn't mention how the ICC implicates into this conflict. Second, on their Vega 20 evidence saying that the ICC is structurally ineffective, they cite this arrest warrant for Bashir and how it didn't have enough evidence, but even in the affirmative world, we're going to contend that the U.S. gives more evidence and money, but that only means more ICC destruction in Africa. Specifically, our Sheffer 09 evidence finds that ICC decisions to pursue investigations and indictment upset delicate diplomatic situations. The ICC announced they would seek an indictment against Sudanese President Omar al-Bashir. The decision to refer the case to the ICC aggravated the situation, put more innocent people at risk. And in response, Bashir expelled humanitarian NGOs from Sudan, and Bashir decided he has nothing to lose and escalate their attacks. So what does this mean? In the affirmative world, the U.S. was forced to fund this organization that is going to continue going into Africa and angering war criminals. Also, per the evidence from our case, Prorock 70 tells you that when the ICC investigates conflicts, it lengthens war by 47% because it forces war criminals into hiding. This is what they're defending. They're saying we should fund an organization that does this, so overall they're funding something that creates more instability in Africa. Fourth, how does the U.S. reshape the ICC or Rome Statute post-affirmative? The ICC has 123 countries. Every single one has an equal vote. The U.S. can't just come in and autocratically say, oh, we're going to change all of the norms in this organization. That's not how international politics works.
Fifth, on this idea of the United States being the most powerful country that can make other countries not investigate us, empirics literally disprove this argument. Our Goldsmith evidence from case delineates specifically that in 2003, when the U.S. was under the jurisdiction of the ICC, they threatened to pull out peacekeeping troops during that time. This literally means that when the U.S. ratifies the ICC and it's under its jurisdiction, they won't be able to politicize the court. They're going to be forced to pull out their troops and pull out humanitarian aid, which we'd say is really bad. Sixth, on choosing judges. Again, they just say that the U.S. can choose judges. That's true, but the process in which they choose the judges is very complex. Again, 123 countries, equal vote. They're not politicizing the court. That's very nebulous. Seventh, on their impact, they have read no evidence on how great powers have incentives to intervene specifically in the Sahel. Insofar as great powers like the United States, Russia, and China are involved in Gaza, Ukraine, and Taiwan, there is no incentive analysis on why these countries would want to intervene in some conflict in Africa. It doesn't make sense.
Alright. The order of the speech will be very simple, just the African and the conflicts. Let me know what everybody is thinking. Okay. On our argument about cooperation, their first response is that we're still in NATO. We would argue that even if the United States is still in one organization, if they pull out of 10, that is still on net bad, which is our argument that is conceded. They say that our sun evidence is bad, that it doesn't isolate a warrant. It does. They specifically conceded that China is doing things like increasing its economic activity and increasing alliances, which comes from our Jose evidence as well, which definitely frontlines this response. They say that which allies are turning. Number one, this is not an actual response that respects the actual substance of our argument, but we would argue that there are examples of countries like the Philippines who are already defecting to China right now, and the BRI is expanding inside of European countries. They say that the U.S. is doing deals anyway. We would argue, what deals are they talking about? The U.S. is pulling out of a bunch of deals. They pulled out of the World Health Organization and things like that. Then their next turn is about how it's going to decrease credibility. The evidence is not about decreasing credibility. It just says broadly that, oh, it's going to infringe upon sovereignty, but we will respond to this on the Africa argument. Their last response is that past actions mean hypocrisy, but we will make the argument that this gives an incentive for them to politicize the court because they need to make it seem like it is a worthwhile diplomatic initiative, which means that this is simply our argument. On the argument about Africa, the first thing they say is that Bangstyle is not about the ICC. It is uniqueness, and they've conceded specific warrants as to why the ICC is key. The Jerusalem evidence that they read specifically finds that the ICC increases conflict by 85%, which should frame your ballot on this question. Then they say that in the app there will be more evidence given. This argument makes no sense. They have conceded specific incentive analysis from Trump that says that he does not want to intervene militarily in Africa, which is a unique reason why he wouldn't do the things that they talk about. Then they say that investigations mean more crime, but this is our argument. We contend that affirming pivots away from Africa. They say, how would you reshape the ICC? But you have conceded the probability rate that says that these countries simply acquiesce because the United States holds these things like economic leverage. And the quote evidence is also cold conceded that says the United States can amend the Rome Statute post-act, which means that fundamentally, it means that all the things that they talk about, like constraining the United States, fundamentally does not happen. Then they say their Goldsmith evidence, then they talk about the Goldsmith evidence about how it happened in Berkeley. The U.S. was not under the jurisdiction of the ICC and never has been. Their argument does not make any sense. It is uniqueness for our case. They say we can't choose judges. No, our evidence, we both have competing warrants, break the clash of evidence. They don't read any. They specifically conceded that the U.S. would be able to do things like pack judges within the court because they have uniquely high things like diplomatic power. Their last incentive is that great powers are not drawn in. But number one, we would argue that our evidence specifically indicates that because they're not beholden to anybody else, that it's uniquely the most likely scenario for escalation, which is conceded. But moreover, we would argue that even if they're correct that it does not cause nuclear escalation, then conventional war is independently bad. Go to their case. On the first argument about a counterproductive court, first, we would argue that most of this argument is just our link. ICC increases conflicts? Yes. So it's a question of what does affirming do? We would argue that affirming does not necessarily increase funding and the things that they talk about. Because we would either at A, because there are countries that, for example, don't give a lot of funding, or B, we would argue that they do give funding, which gives them an incentive to try to politicize the court. Otherwise, Trump is giving funding to an organization he actively opposes, which is the unique reason why he would be pushed to politicize the court. Third, we would argue that their impact evidence that says that that violence is already high globally just concedes our uniqueness to be true. Insofar as that conflict is increasing worldwide, it just proves that the ICC should be shifting away, which is what the United States can do. Finally, we would argue that America First extrapolates to this argument. Insofar as that Trump is America First and he politicizes the ICC, it fundamentally means that he shifts away from global conflicts in total and rather tries to make the ICC as powerless as possible, but to manipulate to his own arguments, which means that we are solving their argument. On the argument about humanitarian efforts, first, we would argue that they read an overview about how the ICC is ineffective and can't enforce anything. If that is true, that is a contradiction, because if the ICC can't enforce anything, why would they stop the United States from doing humanitarian efforts? This argument fundamentally does not make sense. Second, we would argue that Trump is America First, which means that fundamentally he does not want to give aid regardless, which is why historically he has already began cutting aid from things like South Africa, which is what means that their argument has no uniqueness. Third, we would argue that we could just give aid to non-member countries and have those non-member countries give the aid to the nations that they talk about, which allows the United States to circumvent these rulings. Insofar as that's true, it means that we don't necessarily reduce a lot of aid whenever the affirmative happens. Fourth, my point is that the perception is enough to trigger their argument. We would contend the perception is based on reality. If our allies perceive that the United States is politicizing the ICC and that the ICC is opposed to U.S. aid, then the perception is that the U.S. is getting rid of aid's #1 opposition, causing their argument to be turned. For these reasons, we so practical.
So let's talk about politicizing the ICC. You say that the U.S. can just come in and magically make an event. How does that work?
Yeah, we can see an extensive analysis from our evidence that indicates that because the United States is the most powerful nation within the ICC, that they have other countries that they can bring economic sanctions with, other types of leverage. So
it's really clear all other countries in the ICC have a lot of economic leverage. For example, European countries such as Ukraine, Japan, and Great. So my question is, why haven't we already
seen any
sort of politicization of these countries that have your economic leverage?
If you're willing to defend that the most likely way that this would happen is that the United States would acquiesce to Great Britain because Great Britain is a bigger economy than the U.S., feel free to make that argument, but that's not a very reasonable one.
That's not my argument. You're misconstruing it. My argument is, if there are already powerful countries that have a lot of economic leverage on the ICC, why haven't we seen any empirical examples of politicization?
There are. You read an overview about how the court is politicized. We agree.
Wait, that's not true. Our argument is that the ICC, no. Where did I read the overview of the court being politicized?
That is the first thing you read in case. ICC ineffective, court politicized.
That's not true. I did not say the court was politicized. But
sure. Okay. I want to talk more about your argument on, I guess, humanitarian efforts. Sure. Why can't we just give the aid to a country not in the ICC? They can just give it.
I mean, so your response about how Trump is already wanting to cut off aid kind of bolsters this argument. It shows that in the current political environment that we're in, humanitarian aid is already difficult enough to get out. So our argument, if you're proposing that Trump is going to say, oh, we can send aid to other member states and they're going to send it, Trump obviously doesn't like aid. He's not going to take that effort.
So then you need to choose one. You're contradicting yourself. Either does Trump not give aid regardless, or B, does Trump not do the circumvention? You have to choose.
No, our argument is that I'm not contradicting myself. Our argument is when you affirm the resolution, there's two things. Either A, it gets harder for the U.S. to even pass humanitarian aid proposals in the first place because the ICC has liability over them, or B, it makes it harder for the U.S. to send troops to deliver that aid in the first place because they fear the ICC is going to prosecute those troops.
You can get it.
Okay, yeah. So let's talk about Africa. So can you just clarify why in the Sahel specifically the great powers have an incentive to go in and to start a conflict?
Some incentives that we read is that these countries are not beholden to any other power. They're strategically key.
What does that
oil,
mean?
trade. So when that means that, but why is that significant? Because when these countries aren't allies with any other great powers, it gives these great powers a vested interest to try to get involved in the region as much as possible. But I want to clarify to everyone, even if you are winning this argument that great powers do not get drawn in, the argument we will make is that African conflict overall is still a bad. Okay. I guess I want to talk more about humanitarian. We can talk about the counterproductive part, right? If your evidence indicates that we're already living in one of the least peace worlds possible, what does voting for the negative?
Our argument that we're going to contend, especially on your second contention, is when the U.S. complies with the court and exceeds the Rome Statute, it has to fund the court and has to help the court, no matter what Trump wants. Wait really quickly. So our argument is that when you fund this court, it's allowed to conduct more investigations, which empirically have resulted in worse conflict in, for example, Africa. But that's
sure.
Don't build a treehouse on a rotten branch. Even if you think that the ICC facilitates the ability to increase cooperation and decrease the chance of African conflict, we'd say there's still a very compelling reason to keep the status quo and vote next. Humanitarian aid efforts facilitated by the military have helped lift 83 million people out of poverty in 1 year alone, yet their arguments have no historical basis. We'd say our arguments are better on the probability question. One, we have seen humanitarian aid efforts have been decked in 2003 when the U.S. signed onto the Rome Statute, but on their argument on cooperation, we've never seen Trump actually pull out of it. We've seen Trump put out major international organizations like the WHO and NATO, which is their own argument. Yet we haven't seen their impact trigger, and everyone dead. And second, on their entire argument is contingent on the idea of the America First argument, which A, we have never seen happen. It's literally just Trump's rhetoric, what he tells his cabinet members, what he posts on X, and B, it's contingent on a precedent that could change his decisions at any moment while ratifying the ICC is constant. So if you want to suffer their impacts, you're voting next. So, what is our argument? The U.S. military has been key in developing humanitarian aid in war-struck areas. Unfortunately, by subjecting the U.S. to the jurisdiction of the ICC, the fear of prosecution would deter the U.S. from sending military troops. Empirically proven in 2003, when the U.S. threatened to pull out of peacekeepers, they say we never ratified the Rome Statute. No, but we signed it, which means that ratifying it will be even worse. Moreover, Goldsmith explains that with ICC liability, it will be more difficult to propose humanitarian missions in the first place, which is the link that they do not respond to, especially after Trump has threatened to cut U.S. humanitarian aid missions in the past. In addition, Hawley elaborates that the evaluation process for the ICC to determine if missions are vital takes too long, delaying critical aid, and this is bad because overall, U.S. aid and humanitarian aid programs have helped save 83 million people in 1 year. They have a few responses, they're not persuasive. First, they say that the ICC is ineffective, and so the ICC can't enforce anything, so the US wouldn't listen. No, we never said that. We just said the ICC makes conflicts worse. They have conceded that because the US is such a great power, they would face massive international backlash, sanctions, and decreases in FDI, etc. They say Trump is America first, so he won't cut aid. No, he literally said that he would continue US aid in the past couple of weeks. The humanitarian aid program that saved millions. This is our uniqueness, and they've conceded to us. The reason why it's so critical to not affirm is because we're on the brink. Remember, affirming Texas because it's hard to pass humanitarian aid program in the first place. They say perception is grounded in reality. Sure, we agree. We'll get to that later. On their case. On cooperation, they have conceded that their own evidence says that Trump has literally pulled out of major international organizations like the WHO, NATO, etc., which means we should have seen their arguments triggered. If one court is enough to cause all of the impacts to happen, then why did these past 10 agreements, which they say Trump pulled out of, not trigger the impacts? Also, you can turn the argument because they have conceded that it actually politicized the court because Trump has been sanctioning it, denouncing it on the UNSC, so joining would actually decrease legitimacy. On their Africa argument, a lot of this is answered on the weighing on the probability stuff, but we'll still get to it here. Remember, our evidence finds that they tell you the US can amend the Rome Statute post-act. This is not true. The US cannot just make an amendment if they join the ICC, even if they have economic leverage over other countries. They have conceded that there's equal representation, so even if the US is a great power, they still need to abide by its rules. Japan, for example, will fail to use its economic leverage. Don't build it yourself.
The speech is it's going to start on our case, and then the weighing. There's no implication or impact on C1, so we're going for our conclusion. Extend the argument that the ICC is currently mediating right now in Africa, but that backfires for their delusional evidence because the ICC decreases the chance of peace by 20%. That's horrible because they have conceded that the ICC is causing the conflict in Lesotho, which is actively bad and increasing in 2025, which is because of increased jihadist movements and desertification, which they've conceded that if we don't do anything about it, it will draw in global actors that all have a vested interest in this scenario, which causes a great power war, which they have conceded goes nuclear and leads to extinction for nuclear winter. Okay. My opponents just make one response in the last 10 seconds of their speech. They say that U.S. can't amend because of equal representation. They have conceded Ayush's response that no, when we join on and we politicize the court, we force other countries to acquiesce. They have conceded the probability weighing that this is the most likely implementation because other countries, obviously, it's easier for them to just acquiesce diplomatically to the U.S. because the U.S. is the biggest global power. Moreover, prefer our Poe evidence. We actually read evidence over their analytics. Poe indicates that when we affirm the U.S. will fundamentally reform and remodel the institution, do things like pack judges, pack prosecutors to change the court to our interest. At that point, they have conceded that when we affirm because Trump is American first, we focus away from Africa, which solves for our argument. Their way. My opponents go for the probability weighing, but they, in first cross with damning, they can't give you a single example of any other country, Britain, France, Italy, any of the other 125 countries that are member states of the ICC ever cutting humanitarian efforts when you affirm, which means that the probability weighing flips to us. Moreover, they see that we've never seen our impacts happen, but they concede that 2025 is uniquely key, and the probability weighing goes to us insofar as Jerusalem is conceded and finds that the conflicts are getting worse and uniquely now. At that point, our way. Our argument outweighs their case because when we affirm, it links in. We are solving back because the U.S. politicizes the courts, which means that the U.S. bends the court to its will, which means that we won't have any problems with the ICC prosecuting the U.S. for their humanitarian efforts, which means that we can still do humanitarian efforts, which means if we prove that the affirmative case is true, we win the debate. Moreover, our arguments independently outweigh on things like scope and magnitude. There was no impact defense extended in their last speech, which means you buy that our impact is true, that causes a nuclear war between these countries, which means that even if both sides are winning case, you are voting for us on that. Go to their case. I want to point out the first line of the quote from their case. They see that ICC is structurally ineffective because quote, the court is biased and politicized. This is our arguments. Don't let them make new implications in their next speech. They see that funding will do this, but no, funding is an independent reason for why affirming was just politicizing the court, because Trump obviously doesn't want to fund an institution that goes against his will. On the argument about humanitarian efforts, the first response we're going to go for is that our Vega evidence indicates that the ICC is fundamentally a toothless organization. It doesn't have a police force, which means that it can't enforce anything. My opponents just say it makes conflicts worse. This is not responsive. If the ICC fundamentally can't change anything, that means that humanitarian efforts don't go away at the affirmative. Moreover, they concede that we can just circumvent through non-members countries, which is a conceded piece of terminal defense. We are winning the weighing and we are winning the case with on.
No, because in our argument is that after the act happens, Trump will just circumvent by going to country that's not a part of the ICC, like Egypt. Yeah, so we'll have Egypt give the aid instead of
Egypt, the US historically has been the biggest provider.
I agree.
There's still a lot of risk.
100%. 100%. That's the status quo in which the United States isn't inhibited by the ICC. If they were, and if you're taking your argument at its highest level, I think it's much more likely that the United States, to preserve its aid umbrella, would just go through non-member countries and just throw their hands up in the air and say, well, can't do anything about it.
They're going to face massive international backlash, sanctions, and decreases in FBI, but they're not providing their own humanitarian assistance.
They do. They would be able to do it through Egypt. And I got a question. That was yours. I guess, like, on the Africa argument, can you name me a single country that rivals the power of the United States that would not allow it to amend the ICC?
Well, we'd say that in order to actually have the U.S. compete with other powers and stop intervention in Africa, we need to do the next. Because our evidence says that the best way to stop intervention in Africa from spilling over is that we have humanitarian efforts to actually decrease the conflict.
And so which piece of evidence is specifically in Africa that humanitarian efforts stop?
None of your efforts. Obviously, humanitarian efforts. The military is how we access.
Do you read any evidence that says humanitarian efforts stop our case?
The evidence at the top of our case says that humanitarian is contingent on military powers. The military is infrastructure security.
Can I get a follow-up?
Yeah, wait, can I get a follow-up? Yeah. So it's really interesting to mention your case, because your case, the way it is, it's structurally ineffective because the ICC court is, quote, biased and politicized.
I also want to add to Yang.
Can we not stack points really quickly on what Yang said? So you guys keep on bringing up this point about how the court is biased and politicized. That's misconstruing the evidence. Grove says that the only reason why this court is bad is because it would prosecute the U.S. in the case of the affirmative. That's the argument. When the U.S. joins the ICC, the U.S. has prosecuted. Their military efforts are severely hampered. That decks humanitarian efforts. That's
how your Grigor evidence. I'm going to read the quote from your Grigor evidence from the doc. Increasing the perception that the court is biased and politicized. Doesn't seem like we're misconstruing your argument, but you can have a question.
It's talking about prosecution of the United States, but we'll take it.
Yeah, let's talk about the argument on the U.S. and the government. Actually, talking about the ICC's causing conflicts and supplicate. That is true. Wouldn't funding the court cause these conflicts to get worse? Because the U.S. is funding a increasing its credibility for the argument and causing to intervene.
In a vacuum, you're correct. Why would we fund an institution that increases conflict? We do incentive analysis. Yes, they get more funding. What do they do with the funding? Our evidence indicates that because Trump is America first and he's politicized the court, independent
America first is just a lot of better. Right?
No. It specifically talks about African policy. And we've already seen him do things like cut aid from South Africa.
Go to Africa and do this policy.
But also, this is like a new response. It's not new. I guess it's
Yeah. 24 seconds. Starting now. Okay. It's going to be the weighing, our case. On the probability debate, the way you flow this to be a negative is on the empirics. They've conceded that in 2003, when the U.S. signed on to the ICC, it threatened to pull out peacekeeping troops. At this point, history proves our argument to be true, but you have no idea how historically true their argument is. There have been many conflicts in Africa throughout the years, yet we've never seen this great power intervention that they talk about. Also, they have completely conceded the warrant that Tesu puts on probability, which is that if their argument is contingent on Trump taking these actions, Trump's rhetoric and his actions are very irrational and it's really wishy-washy. But you know that the ICC's mandate is constant, conceded probability weighing for us. Also, Also, we are a prerequisite. What they've conceded is that we can solve these African conflicts with U.S. humanitarian aid. They make this warrant that 2025 is uniquely key, but they don't explain the warranting. There's no warrant on this. There have been other conflicts in the past. Then, they say that in Lincoln, the U.S. politicized the court on, I'll get to that on their case. On scope and magnitude, it doesn't matter. For winning probability, it doesn't matter how big their impacts are if they're never going to have it. Extend our argument. It's very simple. The United States military has been the #1 deliverer of humanitarian aid throughout the years. Unfortunately, when you subject the United States to the jurisdiction of the ICC, A, it makes it harder for us to send our troops overseas because we know that our troops are going to be militarily prosecuted by the ICC. But B, the conceded link is that it makes it harder for us to even propose humanitarian aid in the first place because we have ICC liability over us. A conceded link, which means we have 100% strength of link on this argument. They just say that the court can be biased and politicized. They're misconstruing our evidence. That's not what it says. It says that the court is bad because it can prosecute the United States and prevent all of these efforts. That is our argument. Then they say that Vega says that the ICC is a toothless organization. Empirics disprove. In 2003, we literally just signed on and we threatened to pull out peacekeeping troops. History flows to us. Don't go for their theoretical assertions. Then they say that Trump is just going to send aid through non-member states. That's not they don't respond to TSU's frontline, which is that Trump won't do this. The political environment makes it that he hates U.S. aid and he's not going to take this extra effort. On to their case. Again, 2003 empirics disprove that the U.S. can force all of these countries to acquiesce, and it's empirically disproven because we haven't seen it with other powerful countries. Also, every single country has an equal vote on the court. The U.S. cannot politicize it. Look, we're winning the probability win. Case is also probably won.
Order will be
I met him last week.
I'm going to start off on their case, our case, the way. Is everybody good? Even if our argument is improbable, if their argument has a zero risk, then we should win the round. The argument that we are going for is the Vega evidence. It says that ICC is structurally ineffective and lacks the ability to enforce its resolutions. The only response they have extended is the argument about 2003. Not only was this not in summary, but they've specifically conceded our evidence that indicates that overall the ICC does not have enforcement power, which means they can issue a slip of paper, but it does not necessarily mean anything. This implicates their argument, because insofar as that the ICC has no enforcement power, that means that they cannot constrain humanitarian efforts that they talk about, which is conceded terminal defense on their case. Okay, I guess our case. They extend two responses. The first thing is about the 2003 stuff. But no, this 2003 has been the U.S. was not in the ICC. But they've conceded specifically when he joins the ICC, he gains newfound power to do things like bend the court to his will by amending the Rome Statute. The next thing they say is that it is only one vote. But they've conceded our argument about acquiescence. Let's extend the argument. What we contend right now is that the ICC is getting involved in Africa, but they are unsuccessful in doing so because they push leaders inside of a corner. This results in increasing conflict by 20%. When we affirm that the U.S. politicizes the court because they're able to amend the Rome Statute, this is specifically terrible. This is specifically good because Trump prioritizes non-military intervention inside of Africa, which is historically already done in places like South Africa. That is incredibly good because it allows African courts to take central place in these areas, which they have considered decreases the amount of conflicts. Otherwise, it causes broad African wars. 2025 is specifically key because of desertification impacts and also things like the Wagner Group, which were warnings that Yang specifically extended in his summary. Okay, all that, by the way, was conceded. Even if they're correct that nuclear war does not happen, conventional war should still be enough to pull the trigger. Insofar as the weighing debate is very simple. They have conceded that we are solving their arguments. If we win, that we are able to modify the Rome Statute to make sure that it suits America's interests, that means that they can't win their case because they don't constrain America to do things like cut international aid. That argument is cold conceded. They have just really gone hard for this argument about Trump being irrational, but not only do they have any evidence to support this, but we could argue that it is historically true in places like South Africa. Even if we are not winning this argument, insofar as it still amends the Rome Statute, which is a conceded argument from the acquiescence probability weighing, it should be enough for affirmative balance.